Hey, if you're a business owner, listen up. There's a really good chance you're paying for an insurance policy that you personally might not legally need. We are talking about workers' compensation. And the big question is, can you actually opt out? And maybe more importantly, should you? Let's dive in.
So let's just get right to the heart of it. Are you right now paying for insurance coverage for yourself that you aren't legally required to have? Well, for a lot of you, the answer is probably yes. And this is a big but, that yes comes with some really important fine print.
And why should you even care about this? Well, money talks, right? Look at these numbers. By legally excluding just yourself from your company's policy, you could be saving anywhere from $3,000 to, get this, $15,000 every single year. That's some serious cash you could be putting back into your business.
Okay, so let's be super clear about what we're talking about here. A workers' comp exemption, it's not some sneaky loophole. Nope, it's an official, totally legal process. It gives certain qualifying owners the green light to formally opt out of coverage for themselves.
All right, the very first thing you have to wrap your head around is this. Whether or not you can opt out really comes down to how your business is legally set up. This is not a one-size-fits-all deal. The rules are completely different if you're a corporation versus an LLC or a sole proprietor. And this table right here, it pretty much says it all. Your legal starting point changes everything. See, if you're a sole proprietor, the law basically assumes you're out. You actually have to file paperwork to get in. But then, look at corporate officers. It's the complete opposite. You are automatically included, and you have to file a form to get out. And LLCs? They're the wild card. It totally depends on what state you're in. Which brings us to, honestly, the biggest headache in this whole thing: the state laws. There's no single federal rule. Instead, what we have is this messy patchwork of 50 different rule books. And the differences between them can be, well, they can be huge. You know, this quote kind of says it all with a little wink. Everyone in the industry knows how complicated this is. Something that works perfectly in one state might be the exact opposite of what you need to do just one state over.
Just look at ownership roles. In Pennsylvania, a corporate officer only needs to own 5% of the stock to be eligible to opt out. But in California, that number doubles to 10%. And check out the LLCs in Oklahoma and Colorado. Both say 10%, but one defines it by capital, the other by membership interest. Those tiny little words can make all the difference.
And this is where it can get really confusing. If you're an LLC member in Florida, you're automatically covered by default. You have to actively file to get out. But head up to Pennsylvania or Wisconsin, it's a total flip-flop. The law there assumes you're not covered and you have to file paperwork just to get in. It's a complete reversal.
You know, to make this all a little less abstract, let's zoom in and look at a real-world example. We're going to walk through how South Carolina handles this exact process for its business owners.
Okay, so in South Carolina, the magic number is 4. That's it. As soon as you have 4 or more regular employees on the books, boom, workers' comp insurance is now mandatory for your business. That's the trigger.
And the state is really clear about who counts toward that number 4. It's not just your full-time people. It also includes part-timers, any family members you have on payroll, and here's the key part for us: corporate officers are automatically counted as employees, unless they take formal steps to reject that coverage.
So if you're that corporate officer in South Carolina and you want to opt out, this is what you need. This is the key document. It's called the Corporate Officer Notice to Reject, or Form 5. This piece of paper is your official declaration to the state and to your insurance company.
So how does it work? Well, the process itself is pretty straightforward. First, you obviously have to be a real corporate officer. Second, you fill out that Form 5 we just saw. Third, and this is a really important detail, you don't send it to the state. You file it directly with your insurance carrier. And finally, you have to understand the legal gravity of this. You're giving up your right to workers' comp benefits. And that brings us to the biggest question of all, doesn't it? We've talked about the savings, we've walked through the process, but now we have to ask, should you actually do it? Is saving that money worth the risk you're about to take on?
See, a lot of owners opt out because they're running on some really dangerous assumptions. The first one is, oh, my health insurance will cover me. Fact check. Most health insurance policies have an exclusion for work-related injuries. The second one is, I'd never sue my own company. But this isn't about lawsuits. It's about your access to medical care and lost wages if you get hurt. And the last one, I work a desk job. What could happen? Well, injuries can happen anywhere.
So here it is, the trade-off laid bare. On one side, the reward is simple and tempting, lower insurance premiums. But the risks on the other side, they're huge. Your health insurance probably won't pay. You'll be on the hook for every single medical bill out of pocket, and you will have absolutely no access to wage replacement or disability benefits if you can't work. I want you to let this quote really sink in for a second. When you sign that form, you are actively waiving your legal right to collect what could be unlimited medical expenses and unlimited lost wages. This is a massive legal decision you're making, not just a financial one. So, let's just recap the big takeaways here. First, whether you're even eligible depends on two things: your business structure and your state-specific laws. Second, for most of you, this isn't automatic. You have to take action and file the right forms. And third, and this is the big one, making this choice literally transfers all of the financial risk of a workplace injury from an insurance company directly onto your own shoulders.
And of course, we have to say this, and it's really important. This is all for educational purposes. It is not legal advice, it's not insurance advice, so please, before you make any moves, talk to a licensed professional and check directly with your state's workers' compensation board to get the real official rules. So we'll just leave you with this one last question to think about. You know you can save the premium, but can you, your family, and your business truly afford the injury?